Welcome, everyone, to the Federal Bar Association Ketam Sections, the Rounds FCA News with Tejinder Singh. The Rounds is Tejinder's regular analysis of noteworthy FCA decisions and developments. I'm Scott Oswald, Programming Chair of the Ketam Section, here with Tejinder Singh, who is a partner at Sparacino PLLC. Tejinder, hello.
Hey, Scott.
So we've seen a lot of action in the FCA space since we last met. We'll get through as much of that as we can. Let's begin in the U.S. District Court for the Northern District of Alabama with U.S. ex rel. Wallace versus Exactech, Inc., a case that's still in its early stages, but that's attracting a lot of attention. The case features a test of Justice Thomas's recent musing in Polanski versus Executive Health Resources about the possible unconstitutionality of the Ketam provisions of the False Claims Act. Tejinder, you had a role in crafting arguments for the amicus brief that was filed by the Anti-Fraud Coalition in support of the relators here, and you've read the other briefs, including the statement of interest from the United States, which so far hasn't intervened in the case. Tee up what's at stake for us here. It looks like Justice Thomas has, he's kind of reignited a debate that we thought was settled decades ago.
Yeah, the can of worms is definitely open here. So the 11th Circuit is one that did not rule expressly on the Article 2 constitutionality questions when so many other courts did in the 1990s and early 2000s. And so it remains an open question there. And the defendant here has challenged the constitutionality of the Ketam provisions of the False Claims Act under both the appointments and the take care clause. The defendants are represented here by Hogan Lovells, and they put together sort of a suite of constitutional arguments for the district court to consider. As of now, we don't have a decision. We just have a bunch of briefs, but the arguments are clearly being ventilated. And depending on what happens, it is possible that there would be an interlocutory appeal or an appeal after final judgment where this issue would make its way to the 11th Circuit and potentially beyond. It isn't at all clear what the district court will do with this, but I think as the first major challenge to the constitutionality of the FCA since Polanski, this case is being watched very closely by people on all sides.
So let's imagine for a minute that Exactech wins the day here. What are the odds that this argument has legs, that Justice Thomas will ultimately put all of us in the Ketam section who represent relators out of work?
It's always possible, but I think the possibility is it's worse than a coin flip, I think, for the challengers. So if you look at the history of these arguments, every circuit court that has considered them has rejected them. If you look at some of the questions raised in Justice Thomas's dissent, I think they all have relatively straightforward answers. In fact, answers that were adopted by the courts that previously rejected them. I do think that if Exactech wins, you would expect to see the relators and the government appeal that to the 11th Circuit, and then it would become a question of what the Court of Appeals decides to do with the question. And if the 11th Circuit joins all of its sister circuits in rejecting the challenge, I don't think a cert petition would really tend to get anywhere. If the 11th Circuit affirms, though, then you could see a different outcome. If a Court of Appeals deems a federal statute unconstitutional, that's a big deal and probably would mean a Supreme Court case. And so I think that it's very, very hard to predict, but I think the right thing to do at this point is to watch closely. And for those who are interested, to participate in whatever way makes sense, as the Anti-Fraud Coalition did, for example.
Okay. Let's turn to the Courts of Appeal. First up is U.S. ex rel. 84 Partners LLC versus Nuflo, Inc. This is a 9B pleading case before the 11th Circuit. And Tejinder, it seems that the 11th is a pretty tough audience for a 9B argument, even when you're claiming fraud against the Navy's nuclear submarines. What's your take?
Yeah, so this case is really a good illustration of how the 11th Circuit adopts what I think is the most stringent Rule 9B standard of any circuit. There's been an ongoing discussion about whether Rule 9B requires relators to plead specific claims in an FCA case. And the logic goes in the 11th Circuit, yes, you have to do this for two reasons. First, having a claim is an essential element, and so Rule 9b necessarily applies to it. And second, to satisfy Rule 9b, you have to show that claims were presented, because otherwise you might have an instance where there is a fraud that touches both the government and other payers, and you don't really know if the fraud reaches the other payers, reaches the government as opposed to only the other payers. That rule emerged in a case called Clausen, which was about laboratory fraud. And so there you had a lab that was ginning up all sorts of unnecessary tests. And the question was, well, do we really know that they're billing the government for these? And the court says, we don't. And so the case is dismissed. This case shows just how far the 11th Circuit has taken that position. Here, there's really no doubt that the government has paid for the end product. It's a nuclear submarine. And the allegation is that defective parts were supplied for the submarine and that the billing for those parts was subsumed in the overall bills for the product. But they don't have a specific invoice for the parts or even know really where in the invoicing it happened, because it's not itemized like that. And so the 11th Circuit here says, yeah, not good enough, which is very interesting because it seems almost impossible that the government didn't pay for this. And nevertheless, the Court of Appeals found the allegations insufficient.
Moving on to the 10th Circuit, we have U.S. ex rel. Barrick versus Parker-Migliorini International, an FCA retaliation case under Section 3730H. Here, for the first time, the 10th holds that the FCA's because of causation standard for retaliation follows the Supreme Court's but-for model, as expressed by Justice Gorsuch in Bostock versus Clayton County, which allows multiple but-for causes. Tejinder, the defendant here objected to the trial court's use of a simple car accident scenario, which came straight from Bostock. To illustrate the idea of multiple causes. That's an example that I like to use myself at trial. What did the 10th Circuit say?
The 10th Circuit said that the jury instruction was fine. So this is a case that had several issues emerging as it did after jury trial. The one that we're focusing on here is the issue of the FCA's causation standard for retaliation. And really, there are three options for what the causation standard could be. It could be sole cause, right? The only reason you were fired was retaliation. There were no other reasons even in the mix. It could be what the court decides here, which is it's but-for causation, but there can be multiple but-for causes. The car example that you gave is an accident could be caused by a car running a red light, but another car also making an illegal left turn at the same time. That accident has two but-for causes, each of which is independently sufficient to confer liability under the reasoning adopted here. And a third possible standard, which is the one that many plaintiffs have pressed for, is the motivating factor standard. So it didn't need to be a but-for cause, didn't need to rise to that level. It just had to be one of the things you were thinking about. So the 10th Circuit adopts the middle of the road standard and says it's perfectly fine to explain it using the language from Bostock and to use that example in a jury instruction. And so it's a middle of the road holding that rejects the defendant's argument for the more stringent sole source standard.
Next up, U.S. ex rel. Druding versus Care Alternatives before the 3rd Circuit. This decision is about what it means when the U.S. government keeps reimbursing a defendant after it learns of an alleged fraud, and whether that continued reimbursement by itself renders the alleged scheme immaterial under Escobar. Tejinder, our section is hosting a Zoom roundtable on this very topic in early December. But in the meantime, give me your take on the case, which the panel sent back to the jury to decide. Under Escobar, is materiality usually a matter for trial these days?
I think it ought to be. You know, we've been talking about this since 2016, what's going on with Escobar. And we all remember immediately after that decision came down, there was this rush of district courts throwing cases out at the pleading stage or at summary judgment saying, hey, the government kept paying. That means you can't establish materiality as a matter of law. And really, that's what happened here as well. This case was in a summary judgment posture. And the district court said the government's continued payments are really strong evidence of immateriality. We have to throw out the case. And the Third Circuit says, no, they are evidence. That is true. But there are also other factors and complicating factors in this case that you have to consider. And I think a lot of us on the relator side of the ball and the government side of the ball have been saying for a very long time that courts were overreading Escobar. That is, that they were taking this line way too far and throwing out cases when there were countervailing considerations. The Third Circuit's decision is a very good example vindicating that argument. That is to say, you shouldn't, in every case, be throwing out on materiality grounds the cases where the government has kept paying.
Next, we have U.S. versus Walgreen Company at the Fourth Circuit. In this case, the defendants argue that they shouldn't be held liable under the FCA for breaking some eligibility rules because the rules themselves were of dubious legality. What did the Fourth Circuit make of this kind of collateral attack?
Yeah, this is an interesting case. So here, what happened is there was one Walgreens store that was expert at falsifying various forms to make patients look eligible for Medicaid when they weren't. And this resulted in the Walgreens getting a bunch of reimbursements that it otherwise would not have gotten. And then there was guidance from CMS that came out that said these eligibility requirements, which were imposed by the state of Virginia, seemed contrary to the Medicaid Act or may have been contrary to the Medicaid Act. And therefore, the defendant said, okay, look, you can't hold us liable for violating an illegal rule. That's not okay. And the district court actually agreed with the defendant. The government appealed. This is the government of Virginia and the United States, both appealed. And the Fourth Circuit said that the governments were right. For two reasons. First, there was the issue of materiality. So the defendant said it obviously can't be material if it's not even a lawful requirement. And the Fourth Circuit said, no, materiality is about whether you might have influenced the decision maker, not about whether they were thinking about the issue correctly or not. It's a separate question. And so actually materiality can be satisfied even if the underlying requirement is itself invalid, because as long as the government was basing payment decisions on it at the time, that's good enough. Independently, the court says, look, this case is not only about whether you complied with or didn't comply with these eligibility requirements, it's also about the fact that you were lying a lot on the forms you submitted, and that doesn't change because the thing you were lying about may not have been a legal requirement. And so that can still be material, the fact that you were lying. Then there's a separate question, which the governments raised, where they said, in criminal cases, and there are some civil cases holding this as well, a collateral attack on the underlying legal requirement is not a defense to fraud. And that, again, goes hand in glove with the point that I just made, that if you're lying about something, the fact that the thing you're lying about could be collaterally attacked is somewhat beside the point. The point is you were lying. And so the court also accepts that rationale. This is a pretty interesting case and one that I expect will be followed. I wouldn't actually be surprised to see the defendants file a cert petition here. The case was decided in September, so there's still time for them to do that. But it will be very interesting to follow this because I think defendants often want to say, look, if we didn't really break the law, what's the beef here? And I think the government also has an interesting point on the other side, which is, well, you did lie. And so we'll see how this one shapes up going forward.
Finally, we turn our attention to U.S. ex-rel Aldridge versus corporate management out of the Fifth Circuit. In this case, the Fifth slams the United States for what it calls 8 years of dawdling before deciding to intervene, and it orders the trial court to remit a good chunk of the judgment below, saying that many of the government's claims didn't relate back to the original complaint and couldn't be told. The opinion has some very harsh words for prosecutors and for the trial court, which it calls an enabler, but it stops shy of dismissing the entire matter. Tejinder, what happened here? Why all the venom?
So this is a case that I think we've seen cases like this where the investigations drag on for a bit. In this case, a relator filed a complaint in 2007 alleging misconduct that started in roughly 2002. The government started asking for seal extensions in 2007 itself. It would ultimately ask for something like 18 different seal extensions. In 2010, it sought a partial lift of the seal so that it could disclose the investigation to the defendants and start getting information from them. That was granted, it did it. The government continued investigating until 2015, at which point it filed its complaint and intervention, raising claims that both sounded in what the relator did, but also separate misconduct that had emerged during the course of its investigation. The whole thing went through a jury trial. There was about a $10 million plus judgment rendered before trebling. And then on appeal, that was trimmed back on statute of limitations grounds. And the statute of limitations argument that the defendants interposed is they said, look, you drag this out and drag this out and drag this out. And so some of the really old conduct is not encompassed within the scope of your complaint. And so the Fifth Circuit analyzes, as you say, two provisions here: the relation back provision, which is in the False Claims Act itself and describes when the government's complaints and intervention will relate back to the date of the filing of the relator's complaint, and also tolling principles that are inherent in the FCA as well. And in this case, the Fifth Circuit concludes that neither of those provisions allow the government to reach all the way back. And so it ends up cutting the government's recovery about in half by clipping back everything before 2009, which was 6 years before its complaint and intervention.
So what do you think here? I mean, does this rebuke, will it make prosecutors and judges think twice when it comes to seal extensions in the Fifth Circuit? What do you think?
I think yes and no. There are a few things to think about here. So one aspect of the decision that is important is that the government was introducing new allegations different from the misconduct described in the relator's complaint. I think to the extent the allegations are the same or very similar, such that relation back might apply, there would be less of a problem in a case, in a future case. And so it will be a little bit case by case in that sense. That said, you definitely do get the flavor from the Fifth Circuit's opinion that the court was not impressed with the lengthy seal period and investigation, probably thought this whole thing could have been done faster. And I think that there is a sentiment among some judges that that is expected. That is, the FCA provides for a 60-day seal period with possible extensions. And I think very few people reading that statutory language would think like, oh, 8 years is probably about the right amount of time to run an investigation. I think most people would believe that it ought to be carried out, you know, in something like maybe 120, maybe 180 days. And so I do think that it may give some district courts pause in granting repeated seal extensions, especially once you start getting out beyond a year or more. I think it will also provide some incentives for the government to move with a little bit more alacrity, so it doesn't end up in the same position of having a meritorious case that gets chopped in half on statute of limitations grounds. But I think, you know, again, it will just be very case by case. It will depend on if the statute of limitations is in play, whether relation back is an easy or a hard argument, and other factors that will be case specific.
Do you think it matters what the government is actually doing during that seal period and how they're articulating what they're doing in those seal extensions that they're filing? What do you think?
I think it does. I think in this case, the Fifth Circuit was unimpressed with what was in the government's seal extension motions. I think if the government is exercising diligence, it will, of course, have a better argument for tolling. It's also possible, I guess, that the government may start seeking tolling agreements with defendants if what they want to do is stretch out the seal period, conduct an investigation more quietly, as opposed to going loud and litigating in open court. It may be possible that there would be agreements struck during the investigation that would take this argument off the table in future cases. There's all kinds of ways this could go, but I do think that what the government is doing is going to matter a bit.
Tejinder, thank you. And a huge congratulations, by the way, on recently being named TAF Coalition's Lawyer of the Year.
Yeah, thank you. That was a fun one. So that one came on the back of the great success we had in the Schuette versus SuperValu and Proctor versus Safeway cases at the Supreme Court. We've been hearing great things about how the results in those cases have helped clarify the law before many courts that are facing motions based on scienter. And so it looks like the impact of those cases is real, and that's heartening for those of us who participated.
Yeah, 2023 has been quite a year for you. Tejinder, thank you. And thanks to each of you, too, for joining us for the Federal Bar Association Ketam section, the rounds, FCA news with Tejinder Singh. We'll see you next time.